Hello everyone and welcome back to American Federal Government. I am your instructor, Connor Alford, and in this video we're going to begin to talk about one of my absolute favorite topics, as well as arguably the most important topic of the entire semester. And that's going to be the topic of natural rights, both positive and negative. So we're going to talk about what natural rights are, we're going to talk about who has them, we're going to talk about where they come from, and we're going to talk about how they relate to the United States Supreme Court and the United States Constitution. Towards this end, we do have a series of 4 learning objectives that I would like you to focus on as you begin to take notes and move through lecture. The first learning objective for this video asks for you to describe the origin, influence, and core tenets of natural rights theory. The second major learning objective asks for you to distinguish between civil rights and civil liberties and to be able to use the synonyms associated with each of these terms. I'll go ahead and give you a little bit of a spoiler. Civil rights are sometimes called positive rights or entitlements, whereas civil liberties are sometimes called negative rights or freedoms. The reason for these synonyms and this distinction should become evident before the end of lecture. The third major learning objective asks for you to describe the 2 major trends in the development of legal protections for civil rights and civil liberties in the United States of America. Finally, the fourth learning objective asks for you to explain the relationship between our natural rights on the one hand and the United States Constitution, as well as the United States Supreme Court on the other hand. Let's go ahead and get started by talking about the origins and influence of natural rights as an idea. We're going to cover classical liberalism and natural rights theory, the origins and importance of this theory, and then we're going to talk a little bit about what natural rights are, where they come from, who has them, how they are protected or threatened by governments and our Constitution, and we're going to talk about the 2 main types of natural rights mentioned on the previous slide. Let's begin by looking at the term natural rights. A natural right or human right might be defined as a universal right that an individual possesses by his or her nature as a human organism, rather than by law or convention. In other words, a natural right is an inalienable right innate to human nature. These are not rights preserved by legal conventions in a particular country. These are rights that are enjoyed by all members of the human family, simply by virtue of being human. Understand that natural rights are protected legally by the Constitution in our country, but that they do not come from the Constitution, and they are not created by the Constitution or by its interpretation in Supreme Court rulings. Natural rights come not from the Constitution or any other charter of government or act of law, but rather from your nature as a human being. All humans, regardless of where they live or what laws their governments create, whether they are under the jurisdiction of the United States Constitution or not, enjoy the same natural rights. Because of this, natural rights are sometimes called human rights. So, if you are a living organism and you are a member of the species Homo sapiens, then you have a fundamental right to life, liberty, and the pursuit of happiness. Period. End of sentence. This is true without condition or qualification of any kind. Every member of the human family is equally entitled to the same universal, inalienable rights. That idea of natural rights, an individual, inalienable liberty, universal to all members of the human family, is really going to be introduced into human thought in the 17th century by the writings of a number of classical liberal philosophers during the European Enlightenment. In particular, a British philosopher by the name of John Locke was an integral part in popularizing the theory of natural rights. John Locke is generally considered the founding father of classical liberalism. John Locke is also generally considered an intellectual founder of the United States because his ideology of classical liberalism laid out all of the key principles enshrined in the United States Declaration of Independence by Thomas Jefferson, and then carried on into the Constitution by the rest of our framers. Classical liberalism, remember from prior lecture, is an ideology closely related to modern libertarianism, and from which both American conservatism and American liberalism descend. It tells us that governments are established by the consent of the governed, and that they are universally bound by certain limitations which require them to respect the fundamental freedoms of those that established them for their own benefit. In other words, John Locke's classical liberalism fundamentally rested upon the articulation of a theory of natural rights. Classical liberalism placed limitations on the proper function of good government. And for John Locke, these limitations are defined by our individual natural rights. Good and just governments respect people's fundamental freedoms, their natural rights, whereas bad governments violate them. Bad governments can and should be overthrown so that they can be replaced with good governments because they are created by the consent of the governed for the benefit of the governed. This theory of classical liberalism and of natural rights is significant for a number of important reasons. First, the rights articulated in the theory of natural rights are universal. This then provides a transhistorical, transcultural standard against which to judge all governments. Natural rights create certain moral limitations on what governments can and cannot properly do. Governments which go around murdering their citizens arbitrarily are said to be bad or unjust because they are violating the right to life held by those citizens, and this is unnatural. This is improper conduct. Whereas governments that respect the lives and freedom of their citizens and that recognize all members of the human families as persons under the law can be characterized as just because they are, broadly speaking, treating individuals with the dignity that their nature entitles them to. In other words, they are respecting natural rights. The second reason why the theory of natural rights is so significant is that these rights are generally understood to be equal. Right? All humans, regardless of whether they are rich or poor, white or black, male or female, whether they live in the United States under the jurisdiction of the United States Constitution, or they live in North Korea, are entitled to the same universal rights. They are all entitled to the right to life and recognition as a person under the law, to the pursuit of happiness, so on and so forth. And this disrupted the social order of the time because it said that it was unjust for certain people like kings or nobles to enjoy certain rights or freedoms that were being denied to others. So all individuals, regardless of their wealth, regardless of their birth, were equal in the sense that they all had the same fundamental freedoms and that they were all entitled to the same degree of protection for those freedoms from government. Next, the theory of natural rights, articulated by John Locke, is super important because the rights it identified were fundamentally individual. Particular persons are entitled to natural rights. And we distinguish between just and unjust governments not by how they treat groups of people, but by how they treat specific individuals. But let's be clear. Just because individuals are entitled to certain natural rights doesn't mean that these natural rights are always respected. This is where the Constitution features. The Constitution of the United States of America provides legal recognition for and protection of our natural rights in this country. The Constitution and its interpretation by the courts of our country do not create our natural rights. Those come from our nature as human organisms. But they do create legal protections for those rights through a series of legal guarantees. There are two types of guarantees that you need to be familiar with for the purpose of this lecture. There are guarantees about what the government cannot do to us, and these protect our civil liberties by prohibiting government actions that would violate individual freedoms. Then, there are also guarantees about what the government must do for us. And these protect our civil liberties by mandating government actions that help to promote equality. So what are civil rights and civil liberties? Well, a civil liberty might be defined as a natural right protecting us against government action. Civil liberties are freedoms that the government cannot violate, but it doesn't necessarily have to help us to exercise. These are things that we can, generally speaking, do on our own as long as we're left alone. So, for example, you have a civil liberty to free speech, and you have a freedom to remain silent. The government respects your freedom of speech, not by handing you a megaphone or subsidizing your Facebook account, but simply by choosing not to censor you. How does the government respect your natural right to remain silent? By abstaining from actions which would force you to speak out in ways that are incriminating. So the civil liberties protected by our Constitution through prohibitions against government action are natural rights which tell us what the government cannot do to us or take away from us. By contrast, civil rights are goods and services that we are entitled to receive, or actions that the government must actively take, must affirmatively take for us, usually in the interest of ensuring equal conditions, opportunities, and outcomes. An example of a civil right protected under current U.S. constitutional law is the right to legal counsel. You've heard it said before, if you cannot afford an attorney, one will be provided to you. A way to understand this distinction is to recognize that you have a natural right that qualifies as a civil liberty. When you say that I have a right to be an attorney, this is true. I do have a civil liberty, which is a type of natural right to be an attorney. That means that if I want to be an attorney, the government ought not take actions that would make it harder for me to do so. But it does not mean that the government needs to pay for my law school or help me to pass the LSAT if I am unable to do so on my own. If I said that you had a civil right to be an attorney, then yeah, the government would have to pay to give you LSAT classes to help you pass that legal examination so that you could get into a good law school. And if you couldn't pass the bar exam, well then the government would have to hold your hand and walk you through that process. But that's not something recognized under our current law. We have a civil liberty to be an attorney. We do not have a civil right to be an attorney. By contrast, we do have a civil right to receive an attorney. If you cannot pass your bar exam, tough luck. But if you cannot afford an attorney, one will be provided to you. So where civil liberties prohibit government action by telling us what freedoms we are entitled to enjoy, what the government cannot do to us, civil rights mandate government action and are protected through guarantees that tell us what active goods or services the government must provide to us, what the government must do for us. Now, this can become a little bit confusing to many students. And the reason that it can become confusing is that both civil liberties and civil rights are types of natural rights. And because of this, there are certain points in the Constitution where civil liberties are going to be called rights because they are natural rights, but they are then going to protect a freedom rather than preserve an active good or service that we are entitled to receive. So to help clarify, to help clear up some of this confusion, I want to introduce you to some synonyms for each of these different types of natural right. Remember, the first type of natural right that we're going to talk about is the civil liberty. Civil liberties are sometimes called negative rights. They are called negative rights because they are a type of natural right which tell us what the government cannot do to us. They impose negative duties, duties of non-intervention, duties to abstain from taking certain actions. Remember, civil liberties are freedoms that the government cannot take away from us. And because civil liberties are going to tell us what freedoms the government cannot take away from us, sometimes they're very simply called freedoms. Therefore, understand for test purposes that the synonyms associated with the term civil liberty are negative right and freedom, respectively. And remember that civil liberties are protected through prohibitions on government action. In other words, civil liberties fundamentally limit government because governments are the primary threat to individual freedoms. Civil liberties are protected by prohibiting the government from taking actions that violate an individual's freedoms. Civil rights are distinct. Civil rights are sometimes called positive rights or entitlements. Civil rights are called positive rights because they are a type of natural right that tell us what active goods or services the government must provide to us. In other words, they impose positive duties. They ask the government to take affirmative actions on our behalf, usually in the interest of protecting us from unequal treatment in certain settings like the workplace, based on certain characteristics like our race, gender, or disability status. So where civil liberties are primarily threatened by government action and protected by prohibitions on government action, civil rights are facilitated by government action. Where civil liberties tell us what the government cannot do to us, where they prohibit government action, civil rights tell us what the government must do for us. They mandate government action. Where civil liberties limit the size and power of government, where civil liberties limit government action, civil rights mandate government action. They expand the size and activity of government in the interest of equality. So where government is the primary threat to our civil liberties, government is the primary facilitator of civil rights. Now, this doesn't mean that governments can't violate civil rights. They do on a routine basis, but it does mean that you don't have any civil rights without the presence of a government agent or actor. Because remember, a civil right is an entitlement. It is an active good or service that you are entitled to receive from the government, like an attorney, or protection from unequal treatment in the event that you experience racial discrimination at work or in one of your classes. It is important to understand that our negative rights are primarily discussed in the Constitution within what we call the Bill of Rights. Remember from prior lecture that the Bill of Rights encompasses the first 10 amendments to the United States Constitution. And even though it's called the Bill of Rights, it could just as easily and more accurately be called the Bill of Liberties. Because if you read through those first 10 amendments in the United States Constitution, you're going to find that they almost exclusively provide a series of guarantees about what the government shall not do to us. They protect individual freedoms by prohibiting government actions. For instance, the Second Amendment in the United States Constitution protects a civil liberty to keep and bear arms. Now, it calls this civil liberty a right, because remember, civil liberties are just a type of natural right, but if you read the text of the Second Amendment, it goes as follows. The right of the people to keep and bear arms shall not be infringed. So this is telling us what the government shall not do to individuals. It shall not infringe their right to keep and bear arms. So this is protecting a negative right. The reason that I prefer the language of negative rights and positive rights to the language of civil liberties and civil rights is that many times the Constitution uses the term rights in reference to liberties, and that can create some confusion. Positive rights are never explicitly discussed in the Constitution of the United States, because remember, at the time of the American Revolution, at the time that John Locke was writing his 2 treatises on government, that Thomas Jefferson was writing the Declaration, that the framers were writing our Constitution, their primary concern was preserving the freedoms that individuals had enjoyed, which they felt governments were threatening. And therefore, their primary emphasis was on the preservation of a particular type of natural right, the civil liberty. And at that time, nobody had even begun to talk about civil rights, about the positive rights, the active goods or services that we might be entitled to receive from government. So the reason why the Bill of Rights focuses almost exclusively on civil liberties is that nobody at that time had even begun to think about civil rights. So where then do the legal protections for and recognitions of our positive rights come from? Well, they come from the United States Supreme Court's interpretation of the Constitution. And more specifically, they come from a series of Supreme Court rulings in the early 1900s that focused on the 3 Civil War amendments, 13, 14, and 15. And in particular, that focused on a specific clause within the 14th Amendment, which told us that no state shall deny the equal protection of citizens on the basis of their race. The courts, starting in the early 1900s, are going to interpret this equal protection clause of the 14th Amendment to argue that in addition to abstaining from actions which would violate individual freedom, government must actively engage in actions that promote equality. So the most obvious example of this that I can think of is your right to an attorney. You have a right to an attorney. If you cannot afford an attorney, one will be provided to you. But more broadly speaking, I want you to understand that the legal doctrine of positive rights in our country boils down to a legal standard called the Equal Protection Doctrine. And the Equal Protection Doctrine tells us that we are entitled to be protected from unequal treatment on the basis of certain characteristics in certain settings. Those protected characteristics are race, gender, and disability, and those protected settings are the workplace, public goods or services, and education. So we are entitled to be actively protected by the government from discrimination by private actors like our employers or our teachers. All right, now that we know what civil rights and civil liberties are, we know that there are different types of natural right, but that they are distinct in some important ways, let's begin to talk a little bit about historical trends in the development of legal protections for civil rights and civil liberties by and under the American government. We're going to talk a little bit about how our constitutional system of government creates protections for civil rights and civil liberties. We're going to talk about how these protections have changed over time. We're going to talk about what caused these changes. We're going to talk about why these changes matter. So let's begin by reiterating a point that was already brought up. The United States Constitution does not give you any natural rights. It does not create natural rights. The United States Supreme Court does not create natural rights either. However, the United States Constitution does play an important role in this discussion, because while it does not create natural rights, it does codify our civil liberties into law. And it does, in fact, provide legal protections for these civil liberties. So the Constitution of the United States relates to our natural rights, and that it codifies our civil liberties into law. It codifies one of the most important types of natural right into law, and it provides legal protections for these rights in very broad brush strokes. Remember from prior lecture that the Constitution focuses on the big picture. It says things like the freedom of the press shall not be infringed. Congress shall make no law respecting an establishment of religion. It does things like tell us that we're going to have a freedom of speech. But these are all really general. Like, what does that freedom of speech encompass? Does the freedom of speech protect my ability to express controversial opinions through sign language or by making a post on my Facebook wall? Or is it limited to literal speech? Well, if I go and I read the First Amendment, I'm not going to get clear answers to that question. The Constitution focuses on the big picture. There is a freedom of speech. But the Supreme Court of the United States also plays an important role in this process. The United States Supreme Court helps to provide interpretations of these vague protections of civil liberties, and it helps to provide specific applications in particular cases or controversy. In other words, I want you to understand that the Constitution provides the broad protections for our civil liberties, but that the Supreme Court provides the specific protections by telling us how these general principles apply in particular cases. Does the First Amendment freedom of speech protect my ability to criticize a president by making a post on Facebook? Well, the answer to that, legally speaking, is quite simply yes. How do I know that my constitutional freedom of speech encompasses Facebook posts and not just literal verbal articulation? Well, I know because the Supreme Court tells me so. The Constitution never mentions Facebook because Facebook wasn't around at the time that the dang thing was being written. Facebook is really new. The Constitution is literally the oldest living constitution of any country in the world. So we need to look at the Supreme Court to figure out how these big general brushstroke principles like the freedom of speech apply to particular cases. But in addition to helping to interpret and provide specific applications for the Constitution's general protections of our civil liberties, of our negative rights, the Supreme Court is also important because in the United States it is the Supreme Court and its interpretation of the Constitution that codifies our civil rights into law. Remember, the Constitution never explicitly provides any guarantees about any form of active good or service that the government must provide. Instead, what we're going to find is that it's the Supreme Court's interpretation of the Constitution which begins to tell us that in order to promote equality and fulfill the spirit, not the letter, but the spirit of the Constitution, the government must not only abstain from violating freedoms, but must actively engage in providing certain goods and services, like legal counsel, in the event that we have a citizen who cannot afford an attorney. So the Supreme Court is significant because, first, it interprets the general protections of civil liberties in our Constitution so that we know how they apply in specific cases or controversy. And second, because it codifies our civil rights into law through its interpretation of the Constitution. I also want you to understand that the Supreme Court's relationship with our individual rights, our civil liberties, and our civil rights is a complicated one. I want you to understand that the United States Supreme Court, historically speaking, has been both the primary protector and the primary opponent of both civil rights and civil liberties. So, for instance, it was the United States Supreme Court that ruled in Brown versus Board of Education that it is unconstitutional to racially segregate our public schools. But the same Supreme Court ruled in favor of legally mandated racial segregation in the case of Plessy versus Ferguson. It was the United States Supreme Court that ruled in Korematsu that the United States government could take an entire race group of American citizens and imprison them in internment camps without due process of law. But it was also the United States Supreme Court that ruled against the Indian removal. The United States Supreme Court, in certain political climates, has in fact served as a primary protector and facilitator of both civil rights and civil liberties. But in other political contexts, it's been a major opponent. For instance, in peacetime, the United States Supreme Court tends to be pretty willing to protect the individual freedom of speech. But when there's a war going on, or when there's been a national crisis, when you have an event like 9/11, or World War I, or World War II, well, in these contexts, the Supreme Court tends to be very willing to uphold and promote, or even mandate, government actions that actively violate the individual's ability to express controversial opinions. So the Constitution protects our natural rights in very general terms, and the Supreme Court interprets those general protections to provide specific applications. But its interpretations can sometimes be very restrictive, or they can be very active. They can either protect or actively threaten our individual civil rights and civil liberties. And even if you're not a United States citizen, it is important to understand this, because while the codification of civil rights and civil liberties into law originates with the United States Constitution and with the United States Supreme Court, it's not limited to our country. After the Second World War, many of these ideas were taken from the United States Supreme Court and the United States Constitution, and they were globalized through a document called the 1948 Universal Declaration of Human Rights. Because during the Second World War, we had a number of countries which were basically violating the fundamental freedoms and civil rights of their citizens in things like the Holocaust. And they were able to try to justify what they were doing by stating that entire segments of their population were not actually people, they were not actually persons. And to make sure that this never happened again, after the Second World War, a bunch of countries got together under U.S. leadership, and they drafted a document which enshrined into international convention and treaty law the Universal Declaration of Human Rights. Now, we modernized the language, we went from natural rights to human rights, but remember, these are essentially synonymous. A human right is a universal right that all individuals possess by their very nature as human organisms, rather than by any law or convention. A natural right is a universal right that individuals possess by their nature as human organisms, rather than by any law or convention. So the Universal Declaration of Human Rights is really the United States' gift to the world. The doctrine, the regime of human rights originates with the United States through its application of ideas articulated by John Locke and their evolution under Supreme Court jurisprudence after the United States Civil War. But we're not done yet, Because what we're also going to find then is that there are certain changes in the legal treatment of natural rights within our country. So let's focus on the two major historical trends in the legal protection of civil rights and civil liberties within the United States. Now again, I can tell you one major trend is that these rights have been globalized. They've gone from the United States to a worldwide convention. But we're going to focus on how they have evolved specifically in our country. So I want you to understand that the first major historical development in legal protections for civil rights and civil liberties in the United States has been a gradual transition from our early emphasis on individual freedom to a contemporary emphasis on equality. The Bill of Rights, remember, was primarily focused on protecting individual freedom from government incursion by prohibiting government actions that were oppressive. However, today, most Supreme Court rulings tend to prioritize equality over freedom. They tend to focus very heavily on that equal protection doctrine, that individuals are entitled to be actively protected from unequal treatment on the basis of certain characteristics. And if there is ever a point where an individual's freedom comes into conflict with this principle of equality, the modern Supreme Court tends to prioritize equality and rule against individual freedom. That's not how things always existed. What we're going to discover is that originally, our Constitution in our country was more concerned with the preservation of individual liberties and less concerned with the promotion of equality. Whereas today the opposite is true. Under the current Supreme Court, what we're going to find is that our country tends to emphasize equality over freedom and therefore to focus primarily on civil rights rather than civil liberties. The next major trend has been a gradual incorporation of the Bill of Rights against the states. What does this mean? Well, remember, the Bill of Rights protects certain individual liberties like the freedom of speech, the freedom of religion, or the negative right to keep and bear arms. But at the time that the Constitution was written, it was understood that these limitations on government action only applied to the federal government. So, for instance, the First Amendment says that Congress shall make no law respecting an establishment of religion. It's talking about the federal Congress, the Congress of the United States of America, because this is the Constitution of the United States, not of the individual states. South Carolina, North Carolina, the individual states already had their own constitutions with their own limits on state government, and we were writing a federal charter of government with a set of limitations on federal government. So while the federal government could not create a law respecting an establishment of religion, it was originally understood that individual states could, and in fact, many of them did. A majority of the states at that time had an official religion. We still had laws requiring people to do things like baptize their children at the state level, but the federal government could not create such a policy under the United States Constitution and the Bill of Rights. Well, today, it's no longer true that states are able to do things like require people to baptize their children. Why not? Because the Supreme Court, starting with a ruling, in the case of Barron versus Baltimore, has gradually incorporated the Bill of Rights, or fundamental freedoms of religion, speech, and the freedom to keep and bear arms against the states. In other words, incorporation refers to a historical trend by which the United States Supreme Court has applied prohibitions on government action that originally only limited the federal government to the states. So if the Bill of Rights forbids an action by the federal government, it also, under current Supreme Court interpretation, forbids the same action by the states. So what sparked these major historical developments? What led us to shift in our focus on freedom to our contemporary emphasis on equality? What led the Supreme Court to incorporate our individual liberties and their legal protections against the state? Well, the answer to this question, to both of these questions, is the same. The 14th Amendment of the United States Constitution. That's because the 14th Amendment is particularly comprehensive and because the Supreme Court of the United States has taken an extremely liberal approach to its interpretation. The 14th Amendment does a number of really important things. First, it redefines citizenship to encompass the newly emancipated African Americans and their descendants because, of course, remember, the 14th Amendment is one of the 3 Civil War amendments. The preceding amendment, the 13th Amendment, abolished slavery, and now the 14th Amendment is saying, hey, all those slaves need to be treated as equal citizens, not as slaves anymore, and same is true for the descendants. Second, the 14th Amendment provides the eventual basis for the creation of positive rights by the Supreme Court through its inclusion of the Equal Protection Clause, which says that no state shall deny its citizens the equal protection of the law on the basis of their status as a former slave or the descendant of a former slave. In other words, it's telling us that states shouldn't discriminate against their citizens on the basis of skin color. Now note that this technically protects and was intended to protect a negative right, not a positive right. It tells us what government shall not do. Government shall not deny equal protection of the law on the basis of skin color. In other words, it tells us that the government should not discriminate, that it should abstain from discrimination. But starting in the early 1900s, this clause is going to be reinvented and reinterpreted by the United States Supreme Court to create the Equal Protection Doctrine, arguing that it is not enough to abstain from discrimination. In addition to abstaining from discrimination, under the Equal Protection Doctrine, the government must also actively protect citizens from unequal treatment by private actors. Now, again, this wasn't the original understanding of the 14th Amendment discussed by the people who wrote and ratified it. However, in the early 1900s, the Supreme Court is going to argue that the purpose of the Equal Protection Clause was not just to prohibit government discrimination. It was to promote equality in our society. And because they argue the 14th Amendment is there to promote equality in our society, the government must not only abstain from discrimination, it must also provide affirmative protection from discrimination by private actors. And that protection from unequal treatment, well, it's a positive right. Because protection, by the way, is an active service that the government must provide. And according to the Supreme Court, we are entitled to receive that service. So it's a positive right. So it is in the early 1900s that the court's interpretation of the 14th Amendment triggers a transition from our early emphasis on civil liberties or freedoms to our contemporary emphasis on entitlements and equality. The third and final important thing that the 14th Amendment does, which we're going to discuss in this lecture, is provide the basis for the Supreme Court's gradual incorporation of the Bill of Rights against the states. Under Barron v. Baltimore, the Supreme Court ruled that those liberties protected by the United States Constitution, especially in the Bill of Rights, only protected us from violations of our freedoms by the federal government. And that was pretty consistent both with the letter and the spirit of the Constitution, both its literal meaning and its intention. The Constitution was never meant by the framers who wrote it to impose limitations on the states. It was meant to serve as a charter of federal government imposing limits on federal action. But again, in the early 1900s, the Supreme Court begins to rely on the 14th Amendment's Equal Protection Clause to create new legal doctrines. In this case, they're going to create the Incorporation Doctrine, applying the Bill of Rights against the states. Because remember, the 14th Amendment's Equal Protection Doctrine says that states shall not deny equal protection on the basis of skin color. So all of a sudden, we have the first constitutional limitation on what individual states can and cannot do. And the courts are going to argue that it is the federal government's job to enforce this constitutional provision against the states by ensuring that states are providing due process of law. But the courts also have an extremely broad and stretched interpretation of what due process encompasses. Originally, due process meant things like the procedures used in a court of law. But the courts, they take a new approach to that phrase. First, they say that due process has to be non-discriminatory. Whatever process of law a state uses to convict criminals, for example, it has to use the same for a black defendant as for a white defendant. And that's not really the controversial part of this. The more controversial part of the court's interpretation of due process is that they say that due process of law encompasses not just legal processes, legal procedures, but also our substantive rights. They say that that process of law is only due when it promotes, protects, and respects all of the civil liberties discussed in the Bill of Rights. And since states are now required to provide equal due process, those states are also required, according to the court's interpretation of Amendment 14, to respect every civil liberty. Now again, this is all a bit of a stretch from the original intent of the 14th Amendment, but it's based on the Supreme Court's interpretation of that amendment over time. This isn't immediately explicit, and it doesn't happen overnight. It requires a string of Supreme Court cases that start in the 1900s and don't really end until the mid to late 2000s. And in fact, you could argue that it's an ongoing process of incorporation. Bottom line, the 14th Amendment, as interpreted by the United States Supreme Court, is going to trigger both our shift in focus from freedom to equality, from civil liberties to civil rights, and the incorporation of our liberties against the states. And that is the end of this week's lecture.